Seated. We'll hear argument this morning in Case 23-477, United States versus Scrimetti. General Prelager.
Mr. Chief Justice, and may it please the Court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria. But SB 1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as a gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients. SB 1 categorically bans treatment when and only when it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational. That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care, but here Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify the baseline. Because the Equal Protection Clause requires more, this court should remand so that SB 1 can be reviewed under the correct standard. I welcome the court's questions.
Much of your, the latter part of your opening statement suggests that it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's really for minors. So why isn't this simply a case of age classification when it comes to these treatments as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how the state ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference if a girl takes testosterone or if a boy takes testosterone?
So the district court specifically considered this question in detail and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with the cross-sex use of the hormones.
Is there no physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth sex of who is taking those medications.
I'm more interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to a female, and vice versa for estrogen.
So if you take hormones, they will prompt the development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth. And in fact, that's one of the intended effects of these treatments, because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks, and that it leaves regulation of medication unrestricted, even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just...
Counsel, you rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig Reborn and some of the other ones, where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset. And it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally, that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certain prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig B. Bourne, different drinking ages, or Morales, can men and women adopt children in the same way?
And I think the court could recognize that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there's some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think we're asking the court to break new ground in this case. And in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification, but then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
Well, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the CAS report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the CAS report and Sweden, but neither of those
can be
jurisdictions
medically necessary for some minors, but for the general run of minors, do you dispute the proposition, in fact, that in almost all instances, the judgment at the present time of the health authorities in the United Kingdom and Sweden is that the risks and dangers greatly outweigh the benefits? Do you dispute that?
I do dispute that, because if you actually look at how those jurisdictions are addressing this issue, they have not outright banned this care. The CAS report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course, it's true that they have called for a more individualized approach to these issues and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that in England, I'm sorry to interrupt, but time is running out, that the National Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and are already on estrogen, but for those who are under the age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the CAS implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Isn't all of that true?
I believe that all of that's true. It's outside the record in this case. And so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
In your opening brief, you did not mention any of these European developments, and in your reply brief, is it not true that you just relegated the CAS report to a footnote?
So Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically ban it no matter the need. With respect to the CASP report, that isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary CASP is not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief, that's obviously a facial sex classification, but our primary argument is SB1 is worded exactly the same way and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language in a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment. And the court has addressed the question how an equal protection claim should be analyzed when the law in question treats a medical condition or procedure differently based on a characteristic that is associated with just one sex. And that was Geduldig in 1974, reaffirmed in Dobbs in 2022. And neither Bostock nor Dobbs saw any connection between the Bostock reasoning and the Geduldig-Dobbs standard. Bostock did not mention Geduldig, and Dobbs did not mention Bostock. So why should we look to this Bostock-type reasoning here?
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the court's approach in Bostock and what this court has long done under the Equal Protection Clause. In both contexts, the court has made clear that the right to equal treatment is an individual right. So you look at the particular person and see how the law affects them. And the court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose the statute said, let's just talk about puberty blockers. Suppose the statute said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty. So it's ruling out precocious puberty.
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex. And we're doing that because we have an interest in having minors appreciate their sex and not be disdainful.
Well, let me ask
sex.
one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs. And yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex, and that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through,
All right.
and I don't think it's controlled by Dobbs or Geduldig.
Thank you, General.
Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course, we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case, because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think
And
that's an
here,
important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
With
sex.
respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether, the Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected in the laws of those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, to things that are wrong or right. For decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide.
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary?
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification, because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is a discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB 1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state. And it's true, it arises in the context of medical care for transgender youth. But here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will. For a person born male who wants to get to puberty already,
Right.
And you say that that's a kind of under-inclusion problem, and it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee